We have breaking news out of the United States Supreme Court, and both bits of news are bad, although not really unexpected. In the Calkins versus Pritzker case, as well as in the Bevis or National Association for Gun Rights versus Naperville case, both cases involving the Illinois assault weapon ban, which is dealing to semi-automatic rifles and magazines that hold more than 10 rounds, among other things. The U.S. Supreme Court has refused to enter an injunction in either case in favor of gun owners. We're going to break all this down when we come back. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a two-time nominee in two separate categories for the 2024 Gundies, the top male influencer in the Second Amendment space, as well as one of the top voices of the Second Amendment. I am proud and honored to be nominated in both categories. All right, folks, so here's the deal. We've had two bits of news coming out of the U.S. Supreme Court in the last 24 hours or so. Both bits of news are bad, but not really unexpected. There were two, effectively, in my view, somewhat Hail Mary passes that were worth trying, but ultimately did not work out. The first case involved Calkins versus Pritzker. This is the case you may recall, which really laser focused on the fact that there were these massive donations made to two of the Illinois State Supreme Court justices who ultimately, while campaigning, as I understand it, on anti-gun stuff, among other things, and received campaign donations from political Democrats in the state, including the governor, ultimately got on the Illinois Supreme Court and, of course, upheld the governor's prized assault weapon ban. And the request to the United States Supreme Court in Calkins versus Pritzker was asking the United States Supreme Court to get involved and to enjoin the enforcement of the Illinois law before it effectively goes into effect imminently. And the U.S. Supreme Court has, unfortunately, but not surprisingly, denied this application for an injunction in this case. This was not a surprise because, as I've pointed out in prior videos, the current composition of the U.S. Supreme Court's conservatives do not believe that the Due Process Clause really is a basis for challenging these kinds of issues associated with state Supreme Court justices and donations there too. There's a case called Caperton versus Massey from several years ago. It was a 5-4 decision with the swing vote being Justice Kennedy, who's no longer on the court. And it's pretty clear that if you look at the dissents in those cases, the dissenters are still on the U.S. Supreme Court, and including, not for Scalia, but essentially if you look at what the arguments were made by the conservatives in the Caperton versus Massey case, it was pretty clear that the current composition of the Supreme Court was not going to buy into the Calkins argument associated with due process violations under the 14th Amendment with these donations to the Supreme Court justices of Illinois, who in turn ruled in favor of the governor's gun control laws. Now, I'm not saying that's good or bad. Obviously, it's not great looking. It's certainly something that one wonders whether or not those Illinois Supreme Court justices should have recused. But the bottom line is there doesn't appear to be any recourse at the federal level with the U.S. Supreme Court, and that's why the U.S. Supreme Court just denied the injunction requested by Calkins, which means that is not a basis to enjoin or stop, for the moment, the Illinois gun control laws just recently enacted, the so-called assault weapon bans. Likewise, we found out approximately 12 hours ago or so in the National Association for Gun Rights and Bevis case versus the city of Naperville. Likewise, Justice Barrett entered an order that specifically denied the writ of injunction pending cert iori. It was denied also by Justice Barrett and the court, which means that this was not a super shock because there were requests made in this same case, or these cases, I should say, involving the assault weapon ban in Illinois. The U.S. Supreme Court had previously denied the injunction in those cases and told the Seventh Circuit to speed along, which they did. And now the Seventh Circuit, as you recall, in a 2-1 decision with Judge Easterbrook and Judge Wood, two terrible anti-gun judges in the majority in a 2-1 decision, upheld the assault weapon ban in Illinois. This was a request by the National Association for Gun Rights to the U.S. Supreme Court for an injunction which would have enjoined the law from going into effect, but the U.S. Supreme Court, not surprisingly, said no to this Again, I thought this was another Hail Mary pass. Again, I'm not reporting this to you like I'm happy or like it. I'm just telling you that the reality is, because this was an interlocutory basis, meaning in the middle of a case, I did not think the Supreme Court was going to get involved, even though if I were on the court, I would likely be looking to do so, because it seems outrageous that hundreds of thousands, if not millions, of American gun owners in Illinois are going to have their rights violated, as I see it, because the court is not willing to step in to protect Second Amendment rights the way, in my view, they should. But that is just the world we are currently living in. Now, I want to say a couple things. Some people have made the following observation, and I'm not going to say you're wrong on what you're about to say. People have said that how is it possible, Mark, that the Supreme Court talks about that they don't want to get involved in cases in the middle of the case, i.e. interlocutory appeals, and yet we know down there when the United States Court of Appeals for the Fifth Circuit ruled in favor of gun owners in the ghost gun partial frame or receiver case, again, in that case, the Fifth Circuit said that the ATF had overstepped their legal authority, and thus their actions should be enjoined. They should not be allowed to enforce against either the people involved in that case or at one point anyone in the country these laws dealing with quote-unquote ghost guns or partially completed frames or receivers or weapons parts kits, absent going through people acquiring these through a background check process through an FFL. And it is true that if you apply the interlocutory rule, which means that since those cases were still in the middle of the case, why did the U.S. Supreme Court come out and stay those injunctions by the Fifth Circuit in a 5-4 decision where Justice Barrett and Justice Roberts sided with the liberals to allow for the Joe Biden ghost gun rules to go into effect, even though that was the middle of the case? I do understand a little bit of inconsistency there as I see it, where the Supreme Court is willing to get involved on behalf of the government, but not get involved on behalf of the gun owners. And I do think there's a little bit of tension there as to what's going on. I do think that can be explained. And again, I'm not super happy about this, but I'm telling you what I think is going on at the Supreme Court is they viewed the ghost gun situation as really about commercial transactions. It was really a business regulation case, and therefore they were more willing to defer to the government on things involving commercial sales of firearms or firearms parts or gun-related things in ghost guns. I think they viewed all that really in the context of commercial transactions, and that's why Roberts and Barrett went over with the liberal, and Justice Barrett went over with the liberals on that case. I'm not happy, and it's not anything I would do if I were on the Supreme Court, but I'm not. So I do think that is a legit concern on our part. On the other hand, it can be possibly explained away, as I pointed out, by virtue of there's sort of a deference when it comes to the government on these kind of regulations, and there's also deference to the government generally when it comes to commercial transactions and commercial relationships, which the ghost gun cases arguably are, because it affects how you are able to sell these products into the marketplace. The one last thing I will say that causes me some concern, and then I will tell you where I think the assault weapon cases are going. I do want to flag a time period here and a distinction that I think it's important for all of us to keep in the back of our minds about what happened. Keep in mind that in the summer of 2020, the United States Supreme Court did not have Justice Barrett on the court and had Ruth Bader Ginsburg. Justice Barrett replaced Ruth Bader Ginsburg several months thereafter. But in May or June of 2020, there was a case pending before the U.S. Supreme Court called Rogers. The Rogers case came out of the state of New Jersey and the United States Court of Appeals for the Third Circuit. The reason why I bring up the Rogers case is Rogers was essentially identical in all respects to the New York Bruen case, which, as you know, both Rogers and Bruins were cases that dealt with the constitutionality of may issue permitting regimes where people had to show they had a unique, specific need for carrying guns, which was the law in New Jersey and New York at the time. The reason why I bring this up is in 2020, we had obviously 5 votes that concluded these may issue permitting regimes were unconstitutional. We know we had the 5 votes of justices that believed that was the case in the summer of 2020. And why do we know that? Because we know that in the summer of 2022, the United States Supreme Court decided the Bruen case, NYSERPA versus Bruen. And in that NYSERPA versus Bruen case, it said that may issue permitting regimes are unconstitutional. That was a 6-3 victory with the justices in the majority, including Justice John Roberts. The only difference between Bruen and Rogers was the composition of the court, where Justice Barrett was on the court for the Bruen case. Justice Barrett was not on the court for the 2020 Rogers case. So the question becomes is, what is wrong with Chief Justice John Roberts? Because obviously he had 5 votes to knock out the New Jersey may issue permitting law in the Rogers case in 2020. He had the 5 votes. And yet they denied cert. They denied cert in Rogers. And they only granted cert in Bruen after Justice Barrett was added to the court, and then it became 6-3. So I only flag this as an issue because if it ever comes to the point where one of, like a Justice Thomas or a Justice Alito, for the sake of argument, were to no longer be on the court and they were to be replaced by, let's say, a Joe Biden pick, then we're going to go back to the court effectively with John Roberts being the swing vote, which we saw in the summer 2020, which gave rise to the denial of cert in the Rogers case, even though it was identical to Bruen, and 2 years later, we won Bruen 6-3. So again, it does seem to me to speak to, if Chief Justice John Roberts is the swing vote on these Second Amendment cases, will the Supreme Court do anything to protect our rights going forward? I cannot speak to that. But I also want to mention this, the reason why I bring up that dynamic, and to remind you of the difference between Rogers in 2020 and Bruen in 2022. One, we don't even get cert in 2020, and then one, we actually have a huge win in 2022 in Bruen, and the difference there. I only bring this up to you to point out that I simply don't know to what degree is going to happen if we get an assault weapon type case back before the Supreme Court, and what's going to happen with the court if Chief Justice John Roberts is that 5th swing vote. I just don't know how that's going to play out right now. I think right now we would be fine. I think we have 5 and arguably 6 votes in our favor on this assault weapon ban, provided that Roberts is not the swing vote. So with all this said, I think that what is now going to happen, and unfortunately our brothers and sisters in the gun community in Illinois are going to have to suffer under this law for some period of time, but I suspect there's a good chance that in the 2024-2025 term, we may be able to get a semi-automatic rifle ban and a magazine ban case before the U.S. Supreme Court. I don't know if it will come out of the Seventh Circuit because it may take too long for those cases to get through the system, but I could see the Bianchi case out of the United States Court of Appeals for the Fourth Circuit possibly being the next man up, because I do think at some point in the next 6 months, we are going to get a decision in that Bianchi case, which is involving the Maryland assault weapon ban. And again, while that was argued over a year ago before a 3-judge panel, I'm starting to get the inkling, as I've reported before. I think that what may be going on in the Fourth Circuit is they may have en banc that case internally, which is what's dragging this case out dramatically. But again, if they've en banc this Bianchi case, they're certainly going to come out with a ruling that says that the Maryland assault weapon ban is constitutional under the Second Amendment. And if that's the case, that will be a final judgment and allow for a direct appeal, a direct writ of cert to the U.S. Supreme Court, and that is when the rubber will hit the road. And I don't think there needs to be a circuit split anymore because the U.S. Supreme Court just granted cert. I got a whole video coming out on this shortly in the United States versus Fisher case involving the January 6th defendants, and a case that interprets 18 U.S.C. 1512. You don't need to know the details there beyond the fact that there was no circuit split. No circuit split involving the interpretation of 18 U.S.C. 1512C, which is what's really involved in those January 6 cases. And the reason why this is significant is the U.S. Supreme Court granted cert to deal with those cases, even though there's no circuit split. So the fact that we may not have a circuit split in assault weapon cases here in the United States, but it will be a law that affects millions of Americans, I think that the Fisher case is going to be a good precedent for us to be able to get the U.S. Supreme Court to grant cert, even if there's no circuit split between a red state and a blue state as to the constitutionality of, again, these quote-unquote assault weapon bans. And I do think there's a good chance right now that the Bianchi case may have moved into the lead to be the next man up to the U.S. Supreme Court. And again, that will be in the context of a final judgment, so we won't have to deal with these interlocutory appeal concerns where the Supreme Court doesn't like to deal with cases on an interlocutory basis, meaning in the middle of a case. They really like to resolve cases only when they're final, and it looks like the Bianchi case may be finally resolved in the next several months, which will give give the Second Amendment community the chance to go to the U.S. Supreme Court with that case on a final judgment, and then we will all see if when the rubber hits the road, what's going to go on there. Are we going to get thrown under the bus by a Justice Barrett and a Justice Roberts or not? I suspect we're going to be fine, but only time will tell. And again, I share your concerns about where this could go, although I'm cautiously optimistic we're ultimately going to get where we need to be on all of our Second Amendment issues. But, it will take time. The process will play out, and I know it's frustrating to me, and I'm sure it's frustrating to many of you, especially those of you who have to live under the thumb and the heel of these gun control laws passed by blue state Democrats that don't want you to have any form of arms whatsoever, or the right to self-defense for that matter, as best as I can tell. So, all right, well, I hope you've learned a little bit something about the dynamic going on, the unfortunate news out of Calkins and National Association for Gun Rights cases. Not a shock. Unfortunately, it's still always terrible to lose, even if you expect it. But again, let's play this game out. This game is not over by a long shot. So anyway, don't forget to subscribe here to the Four Boxes Diner. Hope you learned something. Make sure you follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.